Welcome back. It is time to go on the docket with attorney John Patrick Dolan, or Patrick. He brings down all your...
use all three names.
Yeah. Welcome, John.
Or as we like to call you, JPD.
JPD.
Good morning, John Patrick Dolan. So first we want to ask you about the affluenza defense. What is this?
Well, in Texas, there was a juvenile who was charged with vehicular manslaughter, and in the juvenile court, a judge found affluenza to be a legitimate defense. Affluenza meaning too affluent to be responsible for your own conduct. It was a big splash in the news, and so one of our state legislators here in California has introduced a bill to ban the affluenza defense in California. We have never had anybody use that yet. It comes under the rubric of diminished capacity, that somehow or other you can't form the criminal intent because of some problem that you have. It's really more of a political move than a legal move, but it is interesting to see that we're responding already to something that has been identified as a defense in Texas and basically saying you're not going to do that here in California.
Very interesting. Let's move on to another subject that actually is kind of important here because we do have a pretty high gay population.
Right.
Talk to us about what's happening in the...
Well, a Ninth Circuit case just came down. There was a case involving an AIDS drug, and one of the parties eliminated an obviously gay juror. The case went against a party, and so they appealed it to the Ninth Circuit. What the Ninth Circuit said was, jurors' status is constitutionally protected if they have a certain sexual orientation. Now, in that case, it doesn't mean that much. It means they had to go back and try the case again. But what it means is the Ninth Circuit, which covers the western United States, has now said sexual orientation is a constitutionally protected status. Why that's important, we have 3 states in the Ninth Circuit who have legislation against same-sex marriage: Oregon, Idaho, and Arizona. And frankly, that decision probably paves the way now for moving to the Supreme Court of the United States and getting a nationwide ruling on sexual orientation and same-sex marriage. So it's a really big deal case that just came down.
And it's a little tricky because at what point does a court say that a certain thing about a juror, a potential juror, could be a conflict of interest?
Well, what they say is you can't discriminate. You can't discriminate because of age, sex, sexual orientation, race, color, etc. So if somebody eliminated all the black jurors on a jury, or eliminated all the females, or eliminated all the Hispanics, there's a way to make a motion to have the case reversed and come back and try it again. You can't discriminate when you allow or go through the jury selection process. And now sexual orientation is protected constitutionally, just like race, creed, color, etc., which is a really big deal because that decision now says there's a constitutional protection to sexual orientation, and if there is, how can any state ban same-sex marriage? That's where it's going to go.
Oh, wow.
But realistically, it happens anyway, right?
Oh, it does, but if it happens too often, really careful lawyers bring it to the court's attention and many times get the entire panel dismissed or get a new case, a new trial.
This could have huge implications.
Indeed.
Thank you, John Patrick Dolan, for joining us. And for more information, go to dolanlawoffices.com.